Robertson.
Something else, but I'll take a call. Thank you very much, Mr. Speaker. Before I commence the substantive part of the bill, I just wanted to clarify where we'd got to on exactly who it is who's in charge of this bill. Quite frankly, I don't think anyone's in charge of the bill at the moment, but what we're hearing from the other side of the House about who's in charge of the bill, it seems as though we have to transport ourselves back in time, which is something we have to do a great deal in this bill, transform ourselves back in time to when Nathan Guy was in his glorious tenure as the Minister of Internal Affairs. So in actual fact, he was in charge of this bill when he was Minister of Internal Affairs. He's no longer the Minister of Internal Affairs and is now in charge of primary industries, as I think we all are aware. He's at least loosely in charge of primary industries. So that's why he came to be delivering the speech, because the bill was in his name. Now, that's the explanation that we've been given, and presumably, Mr. Speaker, when we get to the committee stage of the bill, Chris Tremaine will morph into place and will lead us through the SOP. Having said all of that, that's the explanation that we've been given. It's somewhat undermined by the order paper for today, which actually lists Chris Tremaine as the Minister in charge of the bill for its second reading. So it would be fair to say that the handling of the bill at this point by the government leaves a little to be desired. But, Mr. Speaker, that's reflective of the entire approach that the National Government has had to this bill. I want people to go back to the 20th of November 2009. Quite some time ago, so long ago, Aaron Gilmore was here. He was a valued member of the National Party caucus at that point. Paul Quinn was here as well. It was all the stars were in play. Chris Ockenvold wasn't even grey at that stage. Actually, he didn't have a grey hair on his head in 2009. If we want some cultural reference points, Mr. Speaker, South Africa were the World Rugby champions at that point in 2009. Kim.com hadn't even arrived, so the Prime Minister hadn't worked out that he had to forget who he was yet. He hadn't even arrived. Ian Fletcher was just an old school friend of John Key in 2009. He wasn't running a major security agency. So I want very much about the bill, Mr. Ockenvold, because in 2009, on the 20th of November, when Chris Ockenvold still had his dark locks of hair, that was when this bill was reported back to the House. Maggie Barry wasn't with us then. Maggie Barry wasn't with us in 2009, and so that's that long ago. That's when the government reported back this bill. It came from a select committee that I was a member of. Mr. Bakshi was on the committee. It was a committee. He is still on that. He is a constant force. Nikki Kay, she was on the committee. She's a minister now. John Hayes was on the committee as well, which made it very entertaining. But he's still where he is. That was 2009 when that came back. And it is remarkable, Mr. Speaker, to those on this side of the House, that the government, having sat around with the inquiries bill there, suddenly bursts into life in the wake of the Fonterra crisis. It's hopeless management of this legislation, Mr. Speaker, legislation that I think has widespread support across the House. It is obviously true that the 1908 Inquiries Act is well out of date. It does not cover for the way in which people would expect and want inquiries to be done. And on this side of the House, Mr. Speaker, we obviously accept and support the premise behind the bill. As my colleague Mr. Mallard noted, it emerged from the Law Commission in May 2008. Geoffrey Palmer, at that point in charge of the Law Commission, and went through and quite clearly articulated the need for something between royal commissions on one hand and commissions of inquiry with very little powers on the other. And what has been established by the Law Commission, then taken through the process of policy development and legislation, is a range of options now that mean that we can have the right inquiry for the right situation. And it's quite clear that by enabling under this legislation the ability, for instance, for witnesses to be called on oath is a very important example of the kind of power that people would want in an inquiry. So Annette King, who was then the Minister responsible for the Law Commission, got this in May 2008. No, she was Minister responsible for the Law Commission, I understand, in 2008, and she identified this, moved swiftly, I might say, so that by September 2008, Rick Barker, who was the Minister of Internal Affairs, was able to come and to the House and run down to the clerk's office and put the bill on the table, and there it was in September 2008. Unfortunately, there was an event in November 2008 that we don't dwell on that meant that it moved into the hands of the government, who initially moved quite quickly to get it off to the Select Committee, but unfortunately it has languished significantly since that time. Mr Speaker, Mr Mallard's already alluded to the SOP that he intends that's on the table and that we will debate when we come to the committee stages. I think it is important to address the issue that lies behind that SOP, and that is the question of the level of transparency around these inquiries. We are giving increased powers for inquiries to be called, and according to the bill in front of us, those inquiries are subject to the Official Information Act. That is exactly as it should be. But there will be occasions where the nature of the inquiry means that either evidence or even in some cases potentially findings of an inquiry need to be kept confidential. And Trevor Mallard mentioned briefly the Louise Nicholas-inspired inquiry into police misconduct. That would quite clearly be an inquiry where aspects of the evidence would be kept secret. That is an important thing to do. So the provisions that are contained in Section 15 of the bill are merited. But what concerns us on this side of the House is that we don't believe that the presumption that lies behind Section 15 is as good as it could be. We think that there should be a presumption of openness, that should be the default position, that an inquiry and the evidence that comes to it and the findings from it should be open to the public. That's the spirit in which we would expect these inquiries to be undertaken. And so we are proposing, or Trevor Mallard is proposing, an SOP that puts in place language that says the default presumption is one of openness. Yes, there may well be occasions when we need to make things secret, but in the order of events as we would normally have them, it would be open. We think that's an important change. It means that being subject to the OIA remains the default position, but there will be occasions using the powers under Section 15 for there to be matters kept secret. And we hope that the government, whomever it is who's in charge of the bill tomorrow, will come to the House and treat that SOP with the seriousness that we put it forward. So, Mr Speaker, we do welcome this legislation coming back to the House. There have been a large number of matters on which there could or should have been inquiries since 2009. I have a private member's bill in the ballot to have a proper inquiry into the Rena disaster. I believe that that is long justified. John Hayes can't remember the Rena disaster, it would seem, but that was a significant event, the greatest environmental catastrophe that we've had in New Zealand waters, and it should have been inquired into by now. The inquiries that are capable of being formed under this bill would have been useful in that instance. There are a lot of other things that have happened under this government's watch that could have seen an inquiry. If we actually go back to 2009, there could have been an inquiry into Richard Worth. I don't know if anyone remembers Richard Worth, but he was here when this bill was going through. There could have been an inquiry into what happened with him. We should have had an inquiry into the collapse of Solid Energy and the role of the government and the Minister of SOEs in the collapse of Solid Energy, the appalling incompetent management of our state-owned enterprises.
We don't need this bill to do that.
Well, that could have been done, but this bill would give a range of options for how that inquiry could take place, a range of things, Defence Force cuts, all sorts of matters that could be inquiries could be undertaken. In fact, the government actually needs all of the options that it's got here because there are so many matters that have occurred under their watch that deserve inquiry. So, Mr Speaker, on the Labour Party will be supporting this on second reading. We believe that the SOP the Minister has put forward, Minister Tremaine has put forward, should be deserving of support. We do want to talk through the natural justice provisions that Mr Mallard put forward, but we'd also ask all parties in the House to support Mr Mallard's SOP to ensure that there is a presumption of openness in these inquiries, because I believe that's what New Zealanders would expect of inquiries undertaken by the government.
Holly Walker.
Thank you, Mr Speaker. Well, it's interesting to have